Have you ever hired someone, like really taking your time to check their CV, interview them, ask the hard questions, and then watch them slowly disappoint you? If you have, then this video is for you. Because that feeling, that specific frustration of realizing you may have made the wrong call, is one of the most demoralizing things about running a business. You believed in them, you gave them a chance, and they didn't deliver. So when it comes to paying their salary, the question that sits in your chest is completely understandable. Why should I pay someone who didn't do their job properly? I hear you, and that question makes complete sense. But here is what I want to walk you through today. Because fairness and legality are not always the same thing. And the answer to that question tells us something every employer and employee in Nigeria needs to understand. Imagine this scenario. A businessman hires a personal assistant. At first, he's exactly what he was looking for. He's organized, he's proactive, he manages his calendar, he reminds him of meetings and follows up with clients. He keeps the office running smoothly. For the first few months, he's worth every naira. Then, things begin to change. He starts arriving late. He forgets important appointments. Clients complain that emails are not being answered. Deadlines are missed. The businessman begins to speak to him more than once, more than twice. He apologizes, promises to improve, and for a week or two, things get better. Then they are back to where they started. Eventually, it's time to receive his wages, and the businessman calls him into his office and says, "I'm not paying your salary. You didn't earn it. You've been terrible at your job." I know many people would probably agree with him, and if you're being honest, you probably agree too. After all, why should someone be paid for doing a job poor? But here's where the law takes a different view. Because fairness and legality are not the same thing. Not always. And the answer tells us something every employer and employee in Nigeria needs to understand. To answer that question, we need to identify the issues in the scenario. The first is whether the personal assistant actually performed poorly. The second is whether poor performance automatically gives an employer the legal rights to withhold wages that have already been earned. In Nigeria, the Labour Act requires employers to provide written terms of employment, including matters such as wages and how those wages are to be paid. Once wages become due under the contract, the law does not generally permit an employer to refuse payment simply because they later conclude that the employee's performance was unsatisfactory. Think about it this way. The law recognizes that an employee may perform poorly, but it also expects an employer to deal with poor performance through the proper process, not by withholding wages after they have already been earned. So if an employee has genuinely worked during the period for which they are claiming salary, dissatisfaction with the quality of that work does not automatically extinguish the obligation to pay. And that is where many employers get into legal trouble. Now, before you misunderstand me, let me be clear. I'm not saying an employer must keep an underperforming employee forever. Far from it. An employer has every right to expect results, competence, and professionalism. And when those expectations are not met, the law provides lawful mechanisms for dealing with poor performance. But here's the uncomfortable truth. The biggest mistake in our story wasn't the employee's poor performance. It was the employer's failure to manage it properly. When you hire someone, you assume certain risks. You chose them. You interviewed them. You assessed their qualifications. You decided whether they were the right fit. If 6 months later they aren't performing, that doesn't automatically become their financial problem. It first becomes your management problem. The law does not expect employers to be perfect at hiring, but it expects them to deal with bad hires properly. That means documenting performance concerns, giving feedback, following agreed procedures, and where necessary, ending the employment relationship lawfully. What the law does not generally permit is an employer deciding that salary already earned should no longer be paid. The bigger mistake in our story happened long before the salary became due. The employer spoke to him informally, But where was the documented performance review? Where were the written warnings? Where was the performance improvement plan? Where was the evidence that the employee had been given a fair opportunity to improve? Employment relationships should never be managed informally. They should be managed by a laid down procedure. Because when disputes end up before a court, frustration carries very little weight. Evidence carries much more. And this is exactly why employment contracts matter. A good contract of employment does more than state someone's job title and description. It protects both sides. It tells the employee what's expected, and it tells the employer what to do when those expectations are not met. In other words, it helps you manage the risks that come with hiring people. First, there should be clear and measurable performance expectations. Don't simply say the employee should perform satisfactorily. What does satisfactory performance actually look like for your business? How will it be measured? How often will it be reviewed? Secondly, the contract should contain a structured performance review process, monthly reviews, quarterly appraisals, documented feedback. An employee should never be hearing for the first time when their salary is due that they have allegedly been underperforming for months and so would not be paid. Thirdly, there should be clearly stated consequences. If performance remains unsatisfactory despite support and warnings, what happens? Can the employment be terminated? What procedures must be followed? Those questions should be answered before they ever arise. And finally, every employment contract should contain a properly drafted termination clause. Because if an employee is genuinely unable to perform the role, termination may well be the appropriate response. But termination ends the relationship going forward. It does not erase wages that have already become payable under the contract. Now let me speak to employees. If you're an employee and your employer suddenly refuses to pay your salary because they say you added no value, remember this: an employer's disappointment is not generally a legal basis for withholding wages that have already become due. Don't simply walk away. Protect yourself. Keep copies of your work. Keep your emails. Keep your reports. Keep anything that shows you carried out your responsibilities and did so properly. And if payment is still withheld, make your demand in writing. And before signing any document prepared by your employer, get legal advice. For the employer watching this video, remember this: every hiring decision carries risk. Sometimes you make a great hire, sometimes you won't. But a bad hire does not entitle you to ignore the contracts you signed. Hire carefully, set clear expectations, manage performance properly, document everything, and if the employment relationship has to end it the right way. Remember, the law does not expect employers to make perfect hiring decisions, but it does expect them to deal with bad hires properly. And that's the difference. If you found this video helpful, subscribe to Gorga's Brief. I'm Gorga, and I'll see you in the next one.